Well, good morning, everybody. My name is Joe Englert. You're here now for the second of a five-part series from McGuire Woods about PFAS issues. And the program today is going to be focused on insurance and risk management strategies for dealing with PFAS exposures. So first, just want to thank everybody for coming out. I want to thank our partners here at McGuire Woods, too, Shannon and Adam for putting this together and setting up these panels. And yeah, again, just thanks to everybody for joining. We got a great response, and we've got a good number of participants, which just speaks to the fact that PFAS continues to be of interest to those in the legal community, and still top of mind, despite some changes, which we'll talk about in some of the regulatory priorities of the new administration. So we're going to go through all of that. I assume you may have questions as we go along. We'd ask that if you hold those questions till the end, and hopefully we'll have time to deal with all those questions near the end of the program. So quickly, just to give you a brief roadmap of the presentation, we're going to do just a little bit of introductions. I'm going to introduce the panelists today. Then we're going to go through just really high-level overview of PFAS exposures. I had cut out a fair amount of content last night, kind of giving the background on PFAS, assuming at this point most people are fairly familiar with PFAS and understand that it's bad. And so we're going to kind of go through that and just kind of go through some of the more high-level where things are at from an exposure perspective and what to be on the lookout for. Then we're going to go through and talk about specifically insurance coverage matters, other strategies beyond insurance, or beyond sort of claims-based insurance for managing risk. If we have time, we're going to go and look at a couple exclusions that the insurance market has promulgated to deal with PFAS exposures, and then again, time permitting, go through some of the best practices to maximize insurance recovery in the event that you are facing a PFAS litigation. So first, by way of introduction, I'm Joe Englert, as I mentioned. I'm a partner at McGuire Woods. I'm in the insurance recovery practice group based in Atlanta, and I do 100% insurance recovery. And that includes things like consulting, certainly claims, disputed claims and litigation, bad faith, arbitration, across all lines. PFAS has been something I've been kind of focused on over the last couple of years in terms of not only representing clients in this space, but also doing thought leadership and doing these types of presentations. So glad to have another opportunity and look forward to hearing some questions. At that, I'll turn it over to Michaela.
Thanks, Joe. My name is Michaela Whitman. I'm a partner at McGuire Woods based out in Los Angeles. And like Joe, I focus exclusively on policyholder work and representing corporate insureds and insurance disputes. Joe's introduction was so good. I kind of just want to say ditto to everything he said because I do exactly the same thing Joe does. I'm going to pass it over to Matthew now.
Hey, I'm Matthew Kern. I am a senior vice president in the environmental practice at Marsh McLennan. I'm based in Chicago. I am basically an insurance broker, and within that, I do placement and advisory. I advise clients on their environmental risks, and I go to the insurance market to find policies to effectively transfer those risks. And I look forward to discussing how the market is responding to PFAS.
All right, well, thank you. So as promised, we're going to start here with just giving kind of a brief overview of some of the exposures that a company might face related to PFAS. First, you've got the sort of the suite of risks, regulatory risks. Federal regulatory risk remains, though, federal regulatory, risk, Clean Water Act is one area where the government uses to regulate PFAS. Circle of liability certainly as well. And Biden administration, prior administration, had made PFAS enforcement a priority. They had this PFAS strategic roadmap that was laid out in October of 2021. committed to what they call the whole agency approach. And even near the end, they had promulgated specific new regulations, designated new chemicals. But a lot of that has changed in the last couple months since the new administration has come in. And the administration has signaled, if not outright stated, that it intends to roll back certain PFAS regulations and pending enforcement actions. So specifically, what they've done now is announced that they're scrapping plans for including limits on effluent, levels of PFAS in wastewater and drinking water. So that's one thing for sure that they've rolled back. But anecdotally, they're also pausing some of the litigation challenging CERCO designation for drinking water, which is a signal, a fairly clear signal that they are not going to defend some of the rules during the Biden administration. So obviously, it's still up in the air, but looks like it's going to be a different regulatory environment on the federal level. Now, for states, the states have their own regulatory schemes. Many states have their own PFAS rules and regulations, which will still be enforced and still, be something that companies need to look out for, despite what appears to be a slight rollback, if not severe rollback on the federal level. So you still have things like, subpoenas and requests for information that the states can exercise their regulatory authority. And some of these standards, like in California, are more stringent, and we expect that those states will continue to enforce those despite what's happening on the federal level. And then beyond the regulatory risk, you obviously have the litigation risk, and that has spiraled, certainly over the last several years. 15,000 at least claims against, primarily against manufacturers, but as we're starting to see, it's sort of starting to expand from that, just like asbestos decades ago, right? It started out with just the manufacturers, but then starts to move to different parts of the supply chain, into retailers and and other component manufacturers and things like that. So we've highlighted here or noted here a few cases. The two fast food cases, one against Burger King, one against McDonald's. And these are class actions against fast food companies, claiming this is related to food packaging for both of those lawsuits. We also noted that they're, sort of the end user or the end product manufacturers are starting to see some litigation. We've noted one here out of the Northern District of California, and this was a class action against the sporting goods retailer, alleging that the waterproof coats that they were selling contained PFAS. So just there to note, just sort of set the stage and just kind of give an overview of the fact that PFAS litigation, PFAS regulatory actions continues to be a major concern. And with that, I'm going to turn it over to Michaela to talk about how we can address some of those exposures through insurance.
Thanks, Joe. Yeah, as Joe mentioned, there have been 15,000 lawsuits against manufacturers alone. So insurance coverage has been key for protecting against those lawsuits. And we're going to start with the CGL policy, which is your comprehensive general liability policy. To date, this has been the most important policy against PFA exposure because it covers bodily injury and property damage claims, which have been the majority of the claims in these PFA exposure cases. It's generally written with broad coverage and has a few exclusions. The thing to know about CGL policy, especially for this PFA claims, is that they cover defense costs as well as indemnity obligations, so settlements or judgments. In these PFA cases, defense costs can be very vast. You can rack up millions of dollars very quickly, and your CGL policy will cover all those defense costs. It can have an unlimited duty to defend, and what that means is that if, say, for example, you bought a $10 million policy, but it has an unlimited or out of limits duty to defend, it would be unlimited defense costs. So even though you have $10 million, you could still have $30 million of defense costs that would be covered. The duty to defend is very broad. So that means you only need one allegation in the complaint that would trigger that duty to defend. It doesn't even need to be in a whole cause of action to trigger that policy. It just has to be a single allegation within a policy. Okay. So far, there has been limited coverage litigation about coverage under CGL policies for PFA exposure, but it has happened. And the biggest hurdle so far in the coverage litigation has been the pollution exclusion. There have been cases going both ways. And I'm highlighting two of these cases here because they went in the exact opposite direction. So in Colony Insurance versus Buckeye out of the Western District of North Carolina, it said that the pollution exclusion does not apply to preclude coverage for PFAS because the PFAS are not a traditional contaminant that should be excluded by the pollution exclusion. However, in Grange Insurance Co. versus Cyclotex out of the Northern District of Georgia, the judge ruled the exact opposite way and said the PFAS are traditional contaminants and should be excluded by the pollution exclusion. Pollution exclusions can vary greatly between policies, and you have to look at what the pollution exclusion specifically says and when it was issued. And that's one of the other things I didn't touch on last slide, but I just want to mention. Legacy CGL policies are going to be crucial in these PFA cases. So that means when I say legacy CGL policies, that means policies that were issued, in the 50s, 60s, 70s, a long time ago, when PFA exposure could have occurred. So for example, if your company used PFAs in the 60s and 70s and an individual was exposed to harm then, and they didn't recognize the injury until the 80s or until current day and sued you, it would be the policies back in the 60s, 70s that were in place when the exposure happened. So those policies, going back and having those policies, are going to be what is actually providing the coverage for those PFA exposures, even though the harm was not apparent until current day. And the pollution exclusion can vary greatly between those policies, depending on when they were issued. So you're going to want to pay special attention to what that pollution policy specifically says. Other hurdles that have come up so far are the expected and intended exclusion and the trigger of coverage. So there has been litigation over PFAS where the insurance company has argued that, you expected or intended this harm to happen because you used the chemicals that had PFAS in them, or you expected that to happen. In James River, out of the Northern District of Georgia, the court held that should not apply in this case, but it's something that the insurers are definitely going to continue to try to use to exclude coverage. Trigger of coverage is also going to be an issue here because it can be difficult to know when an individual was exposed to the PFAS. So going back to that example, when there's exposure in the 60s and 70s and the harm was not discovered until much later, when in the 60s or 70s did that exposure happen, to know which policy was triggered. There's a case, Crum v. Forster, where the judge said, you couldn't tell when it happened, and so you had a duty to defend under those policies. So if there was allegations between 1950 and 1970, all those policies were triggered. Now it's more difficult when the complaint says the exposure happened in 1985 and no other time. In that case, the only policy that would have exposure is that 1985 policy. You couldn't go back and say, okay, the earlier policies were also triggered because there's no chance whatsoever the exposure happened during that time. So when you get the underlying complaint, you're going to want to pay close attention to when that exposure occurred.
Yeah, and Michaela, one other thing I was just going to mention, when we're talking about CGL coverage too, it's important to keep in mind that not only policies that you might have or your successor might have had access to for historical policies, but there may be other either indemnification agreements with vendors or suppliers or additional insured rights under policies issued to suppliers or vendors that you might be able to take advantage of too. So think about those sort of additional insured and indemnification rights as well.
Yeah, that's a great point. You always want to be looking at all sources of recovery. So aside from other policies, just where else could I have coverage for these claims? Could I be an additional insured somewhere? Do I have in the indemnification agreements? Okay, I'm going to move on to pollution liability policies. These are specific policies that you can purchase for pollution-related claims. They are claims made, so a little bit different than the CGL policy. It's not when the exposure to the PFA happened. It's when the claim was actually made against you. So if someone has bodily injury from PFAS, they tender a lawsuit to you, that is when the claim is made. So that is the policy that would be triggered in that situation. People are tailoring these policies currently to PFAS exposure. Matt's going to talk a little bit about that later, but just wanted to let you know that it is possible to go into your broker and say, I want a pollution liability policy that would specifically cover PFAS and for claims that are coming in now. It can provide overlapping coverage with your CGL policy. So when a claim comes in, don't assume that only my PLL policy or my CGL policy applies. They could both apply to provide coverage here. Just like CGL policies, you still want to make sure you're keeping an eye on potential hurdles to coverage, such as retroactive dates and known pollution exclusions. And when I say known pollution exclusions, I mean when you're applying for that policy and they say, do you know of any potential PFAS usage? If you say no, and then you make a claim for a PFAS exposure and you knew it was there, they're going to say that was a known condition that you should have let us know was there, if you know it. If you don't know it's there, you don't know your company used those PFAS 25 years ago, then it's not something you could have disclosed to the insurance company. Okay. One other type of coverage I wanted to mention was D&O coverage. There hasn't been any litigation against this yet, but it's something in the future we see could be kicking in. For example, derivative lawsuits, breach of fiduciary duty claims, alleging that the company and officer knew of the PFA contamination and didn't do anything despite that knowledge. Those are the kinds of allegations we've heard that are kicking around. There hasn't yet been a lawsuit, as I said, but keep the D&O policy in mind as these become more of an issue. They can also cover deceptive trade practices claims, marketing claims. It's not limited to just shareholder drift lawsuits, breach of fiduciary lawsuits. And that's a good segue into remember, check all your policies. Don't assume, I only went through 3 policies here, but don't assume that it's just these 3 policies. You really want to look at what the claim is against you, what losses are you suffering, what's the damage alleged, and consider all policies.
Michaela, before we go, one question I had or a point. So when we're talking about the difference between the marketing claims versus the maybe other types of claims like personal injury claims, so would those types of marketing claims, wouldn't be covered under a PLL or a CGL?
Well, I mean, CGL can cover advertising injury, so you'd have to see exactly what was alleged there. When you think of CGL, you don't often think of the advertising injury, but it is there, so you don't want to overlook it. And your CGL can have specific, and that's a good point, Joe, can have specific endorsements that provide other coverage, especially in construction type policies, wrap policies. They can provide coverage for other things you don't even know are there. And on these legacy policies, things could have been added in the 60s and 70s for coverage that were specific to your company that you wouldn't know unless you went and read the 200 pages of the policy. So really read your policy closely to know what coverage it provides.
Yeah, and we'll get into this in the best practice, but don't always believe what you hear from the insurer, right? So they may say, have a blanket, sort of boilerplate response that says, this isn't a bodily injury claim, right? So if they're alleging that it's an economic injury or like a marketing unfair advertising, and they say, well, it's an economic injury, it's not bodily injury, we're not going to cover it. But as Michaela pointed out, that's not always the case. And so you need to look at everything closely. So sorry about that, Michaela. I didn't mean to interrupt.
No, that actually just came up. Don't, to that point, don't always believe sorry, Matt, don't always believe the broker either. Nothing wrong against brokers, but I just had a case where they said the pollution exclusion was X in certain policies for PFAS exposure, and it turned out it wasn't. And they had a different pollution exclusion in some of those policies. And we only knew that by combing through the policy and seeing what was actually there and when that pollution exclusion had been changed. So do your own due diligence. Turning that over to Matt. I hope you're not mad at me, Matt, for that little dig against brokers. It wasn't personal, I promise.
No, it's just the right brokers.
The right brokers, right.
Yeah, so thank you. I'm going to talk a little bit about, how we can proactively manage PFAS risks going forward and what the insurance market is currently doing with respect to PFAS. And the general consensus and the reality is that markets are starting to exclude PFAS just right out the gate. If they suspect that there is even a slight bit of PFAS exposure, they will apply an exclusion without sufficient data. And I think the reason why the insurance carriers are taking this approach is because PFAS has been used since the 1940s, but it only became a significant environmental concern really in the last 5 to 10 years. So it wasn't monitored as closely as other more well understood pollution risks like petroleum, chlorinated solvents, and such. So the metaphor I always go to kind of describe the underwriter's perspective with PFAS is they're flying an airplane over the ocean at night with no instruments, and there might be a hurricane out there. So the best way that we can get the underwriters and the carriers to come around and provide some coverage is basically to turn those instruments on. And the way we do that is by getting data. And the first step in getting this data is figuring out where a company falls within what I call the taxonomy of liability. Obviously, the companies that make the chemicals have the greatest liability. But then the next tier are companies who either use the chemicals in their manufacturing processes. They have the chemicals stored on site, they handle them, they apply them to their products, they dispose of them. But then there are companies that own property or owned properties where PFAS chemicals were used previously. And as I'm sure you all know, under CERCLA, there's the owner liability. And the colloquialism I like to use with that is, even if you didn't break it, you still bought it. And that's the next tier of liability with PFAS. But then a lot of our companies and a lot of the companies that I work with, they have simple supply chain exposure. They don't handle the chemicals, they don't store the chemicals, but they do handle components that were treated with these chemicals by upstream suppliers or that were applied to products that they make downstream. So while they don't handle the chemicals themselves, they have, sort of their fingerprints on the exposure and can be brought into claims as a result. And then fire suppression is a big one. And this is actually where I've seen the most claim activity. The aqueous film forming foam, or AFFF, is a very effective fire suppression chemical. It basically covers the fire like a blanket, starves the oxygen, and puts it out. Unfortunately, it also contains PFAS, and I have seen multi-million-dollar cleanup and toxic tort demands by use of the chemical to put out a fire, and in some cases, accidental dispersal of the chemical because of a power surge or some malfunction in the fire suppression system. And one of my favorite stories, it's kind of a scary story, but I did have a client who had a fire at one of their facilities, and they used AFFF to extinguish it. And when they got the cleanup bill from the EPA, the risk manager's exact words to me were, would have been cheaper to let it burn down. And I kind of laughed and said, I certainly sympathize, but please don't tell your property underwriter that. Then finally, we have product liability, and that's just really more on the retail side. I have had a number of retailers reach out to me to discuss this exposure because they said, all we really do is put clothes on racks and sell them. Do we have liability? And unfortunately, you do. We have seen claims against retailers largely based on quote unquote greenwashing, where they, basically the plaintiff says, you say you're this green company, but here you are selling products that has this dangerous chemical in it. But we have seen some alleged bodily injury claims as well. And then finally at the bottom is waste disposal and beneficial reuse. And really where I'm going with this is biosolids. This is a huge exposure for the water and wastewater treatment industries. They'll take their biosolid sludge that they generate from wastewater treatment, and they'll sell it to farmers for fertilizer and land application. And it's not just wastewater treatment plants. A lot of manufacturers, they treat their own wastewater on site, and they will sell the biosolid sludge as well. So that is definitely a product exposure that we have seen a lot of claim activity on, as well as inquiries from my clients and prospects. And this here just gives you an example, for manufacturing risks, some of the products that contain PFAS. And as you can see, it's in a lot of different types of products. But really what you want to do is, with your clients and with the companies that you work with, is find out where they fall within the taxonomy of liability, and then kind of drill down as to what specific products contain PFAS. Because if we get that data to the underwriter, it may not make an exclusion go away, but it can make it less onerous. Sometimes we can make the exclusion go away, but otherwise, we leverage this data to, get a coverage for PFAS that does, protect the carrier, but also provide some meaningful coverage for the insured. Then the next step is to, once you figure out, the taxonomy of this liability, how do we get this data gathered at the insured level to present to the carriers? So this is kind of my flow chart for what I use with my clients. We have the risk management at the top. That's primarily who we work with, are the risk managers. But then there's sort of three buckets where we can get the data. Environmental health and safety is first and foremost. They're the ones who are going to be closest to this from a technical level. They're going to understand, PFAS chemicals used or stored at facilities. They're going to have access to phase ones for, properties to determine historic exposure. They'll also be able to speak to the supply chain usage. And, my advice, whenever you're placing a pollution policy or renewing a pollution policy or a general liability policy, is to involve the environmental health and safety team in those renewal and placement discussions. Because when the risk management team and the environmental health and safety team are aligned, we can get great coverage. And it also creates internal efficiencies and communication benefits within the insured's own operations. Obviously, in-house legal, they're the ones who are going to be able to speak to active cleanups, any private party lawsuits. Have we gotten any scary letters from regulators or plaintiffs' attorneys, indicating that we might have an issue with this? And then the facility managers and procurement, they're the boots on the ground. They're going to be able to speak to the AFFF, what kind of facilities have fire suppression that uses this material? Have there been any releases in response to a fire or accidental dispersals? They'll also be able to speak to PFAS within the supply chain. But once we get these three resources at the insured level aligned, we can work towards mitigating the PFAS risk and effectively transferring it to an insurance carrier. So the strategies to address the risk, obviously, determine the full extent of PFAS usage, both current and historic. We can do this through internal audits. A lot of times insureds will just send me all the phase ones and environmental desktop reviews that they have, and I'll put it into a table identifying which sites, have an elevated environmental risk, moderate, low, as well as exposure to PFAS. And then a lot of our insureds are trying to replace PFAS chemicals to the extent that it's feasible. And the biggest example of this is the use of fluorine-free foam, or F3. The challenge there is that replacing AFFF and fire suppression systems is not simply a matter of switching chemicals out of tanks. You basically have to redo the entire fire suppression system to allow this new type of foam, the fluorine-free foam, to be dispersed effectively in the fire. And they will also have to liaise with the local fire departments, because a lot of times fire departments will respond to a fire where there's a chemical or petroleum component where water is not going to be sufficient in the response, and they'll bring the AFFF on site and use it to put out the fire. And I have a couple of clients where not only are they replacing their fire suppression systems with fluorine-free foam, but they're also storing tanks of this fluorine-free foam on site. And they're telling the fire department, if you have to come out here, don't use AFFF. We have F3 foam right here. Hook up and use that. But the challenges, with addressing this risk are obviously the long-term usage, the ongoing regulatory and toxic tort activity. And with respect to toxic tort, one area I'll focus on is the use of geographic information systems, where basically they're mapping sites that can be used for a wide variety of applications. And we are starting to see a lot of environmentally focused GIS websites. And there's one, I think it's done by the Environmental Working Group, where they basically have a searchable map of the United States, and you type in an address and it'll show you if that property is known or suspected to have used PFAS, or if there are properties within the vicinity that have that designation. Other challenges are, we still rely on these chemicals. Despite the environmental concerns, they are very good at what they do for fireproofing, waterproofing, stain-proofing. Supply chain interruption is a major risk that we deal with all the time, and trying to transition away from PFAS is something that will certainly impact, any sort of risk to supply chain interruptions. A lot of alternatives, they can't match the PFAS properties yet, although they're certainly working on that. Time frames for replacement, unfortunately, you're talking about anywhere from a 1 to 5 year window to effectively transition these chemicals, which does nothing to address the historic exposure. And in the meantime, regulatory activity and toxic tort activity moves a lot faster than what this transition is going to be able to achieve. And then, of course, at the bottom here is what I call the unintended consequences, regrettable substitutions. Whatever we replace PFAS with could have its own unforeseen environmental issues. The example I always go to is leaded gasoline. MTBE was, put in place to replace leaded gasoline because that was a major environmental concern. MTBE created its own problems. And that's where pollution insurance can really benefit, because for all of the issues we're having with PFAS, the definition of pollution conditions within the pollution policies I place is extremely broad. It's basically any solid, liquid, gaseous, hazardous material, contaminant, irritant. The general rule we apply is anytime a large amount of something ends up where it shouldn't, it could be considered a pollutant, certainly by a GL carrier that has a pollution exclusion. So the pollution policies are very broad and can certainly capture these regrettable substitutions that may arise as we transition away from the PFAS chemicals. And then in terms of what we can do within the insurance market, what I'll really touch on is here at the bottom, how we can negotiate with carriers to, if we can't remove a PFAS exclusion, provide some kind of meaningful coverage. And the advantage with pollution insurance policies is they are surplus lines policies. The disadvantage is they're not backed by state guarantee funds. There are surplus lines taxes applied to the premiums. But the advantage is there's non-standardized policies. So we can manuscript language, and we partner often with attorneys to do this, particularly in transactional risks, where we can modify the language of the exclusion that does provide some meaningful coverage to the insured. And some of these examples are voluntary site investigation exclusion. That's basically a carrier's way of saying, okay, we'll cover historic pollution issues at your site as long as you don't go looking for problems. Now, if the EPA or a state regulator suspects that you have an issue and they order you to conduct sampling and you find PFAS, then we do have the coverage for it. And for a number of my insureds, particularly the ones who have supply chain exposure, I have been able to get a voluntary site investigation exclusion limited to PFAS only. And the insured is usually okay with accepting that restriction because their philosophy is we're not going to look for this stuff unless someone tells us to. Where this exclusion can present challenges is in a transactional risk where you have a site and a buyer wants to do a phase 2. That will trigger that exclusion. So we always advise our clients, to push back on any demands to perform phase 2 sampling unless it's absolutely critical to the deal. We can also get PFAS for new conditions only. We do that all the time. Historic issues are really the main concern with PFAS, but if there's a release of PFAS chemicals at a facility after a policy is in place, we can get coverage for those types of pollutant releases, cleanup as well as toxic tort. And then there's time element coverage. This usually comes into play for AFFF. And our pollution policies, they'll cover sudden and accidental pollution issues that begin and end within a specified time frame. But we also cover gradual. So if there's a pollution incident tomorrow, but you don't find out about it until 6 months later, you have the coverage for that too. But for risks with heavy AFFF exposure, carriers will limit that to time element coverage, which is great for addressing an AFFF dispersal. And then there is a number of bills in Congress right now, like the PFAS Liability Protection Act and the Passive Receiver Act, that are going to provide immunity from CERCLA liability for certain industry sectors that are exposed to PFAS. And should those bills get signed into law, then I'm going to go to my insurance carriers and say, okay, in lieu of a PFAS exclusion, put an immunities condition endorsement on the policy for PFAS. And what that means is if an insured gets brought into a PFAS claim, they assert their immunities on their own dime. And if the government says, no, immunities don't apply here, you're liable, pay up, then the insurance is triggered for their benefit. And then we also work with excess of indemnity policies where, if you're selling a property, the buyer wants indemnity, we can get a pollution insurance policy to sit excess of the indemnity that a seller is providing to the buyer. And in those situations, it's a financial underwrite rather than a technical underwrite because they'll be looking to the indemnitor's financials as opposed to the conditions at the site. And we can get PFAS exclusions removed all the time, as well as exclusions for known pollution conditions with excess of indemnity policies that we place. And then finally, there's sublimits and higher retentions. I placed a pollution policy for a water utility with no PFAS exclusion, but they did apply a higher deductible for PFAS claims. And that's something that carriers are usually amenable to doing.
So,
Matt, I'll hand it over.
Yeah, thanks, Matt. Before I move to the next subject, I had a question. So one of the things that's come up with clients when we're looking at pollution liability policies to address PFAS or other environmental risks is this question about how hard do you look in the sense that, there's exclusions or conditions sometimes in the policies that, obviously if it's a known issue, then it won't be covered. But you also have to deal with a potential risk that you get a claim and then there's they look into it and they say, oh, somebody had some notice about a PFAS issue. And so there's some conflicting, right? Maybe you get better commercial terms if you can just say, I'm not, we don't know, or we haven't, we're not aware of any PFAS. But if you do another, layer of diligence and do some testing, you identify it, then you can schedule it and disclose it and be more confident that you'll get coverage if there later is a problem. So just curious there's no right answer, but just curious if you had some thoughts on that, question or that issue.
I mean, for due diligence, the phase 1 environmental site assessment, they're now starting to include an assessment of PFAS risk. And, if we have a consultant opinion saying that the PFAS risk is minimal to non-existent, we can use that language within the phase 1 to argue that exclusion away. If there is a PFAS risk identified, but we don't have any phase 2, any soil sampling, groundwater testing data, then we can, try to get some kind of restricted PFAS coverage, like maybe a government mandated trigger for cleanup if PFAS is detected. And, or we could limit it to on-site. If we do have soil groundwater testing that identifies PFAS as an issue, sometimes, if we can demonstrate that PFAS is combined to the property, then we'll have an exclusion for on-site cleanup. But if we discover later on that the PFAS is migrating off-site and we have to clean up third-party property in addition to the insured property, we can get coverage for those off-site claims. And then, sometimes what we'll do is an area of concern approach, where if we can demonstrate that the PFAS contamination is highly localized to a particular area of the site, then we will have that exclusion limited just to that one area of the site and no other part of the property. So if it's found that the PFAS actually did migrate to another area of the site, we can get that coverage as well.
Very good. Well, thank you, Matt. Really appreciate that. And just a reminder to the group too, some people have posted some questions. in the chat, and so I didn't mention that earlier, but if you have questions, we'll want to try to deal with them at the end generally, but and we've got a couple so far, but please go ahead and put those in the chat, and then we'll try to get to as many of as we can near the end. So real quickly, Michaela was talking about before Matt was, about the CGL coverage and the coverage which is the coverage that's going to be the sort of the first line of defense, at least for these, the type of lawsuits that we've seen that are focused on, personal injury, bodily injury, or even property damage claims is the CGL. And those occurrence-based policies, again, that you're going to look back historically to try to find those policies in the years of exposure. So that's, you're still going to have that for historical risk. The sort of the go-forward coverage for PFAS under the CGL, as Matt mentioned, is sort of going away, and that at least for clients that I've seen anecdotally that have a PFAS as part of a known exposure for them, that we're seeing, and even kind of that a layer of beyond certainly manufacturers, but others in the supply chain, that the carriers are insisting now on PFAS exclusions in their CGL policies. And so with the intent, we think, to try to ring fence or exclude that type of liability going forward. Again, doesn't necessarily address the historical liabilities. And in fact, as a policyholder and lawyer, I would say the fact that they're adding these exclusions now proactively maybe suggests that before they added those exclusions, there should be some coverage, and that the pollution exclusion isn't a silver bullet defense. But anyway, there's two forms I want to cover quickly in terms of exclusions that we've seen in the market, two primary ones. One's from the London market, and this is a very broadly worded exclusion. It's what they have this sort of broad language that says, what's sometimes called the anti-concurrent causation language, that says any liability directly or indirectly related to PFAS, right? That's going to be excluded. So it's a broad exclusion, but it is limited specifically to liability that stems from exposure to PFAS, which, and the one point I want to make a little bit with the difference between that and the other major form, which is the ISO form, which is that the ISO form has more narrow causation language, but has some other problematic language that could be an issue. So just the prior exclusion, this is a London market exclusion. You'll see it sometimes, certainly if you're on a London program, or if you've got folks that are on the tower that are London insurers. But the ISO is a insurance services organization. You'll see it typically in U.S. policies. Most CGL policies are written on an ISO form or based on an ISO form, and so this is just an exclusion that you'll see in a lot of American insurers will add. But this one is problematic. I just want to point out, at least potentially problematic, because the way they define PFAS here is, if you see, it'll include, so if going to subsection B, the following is added to the definitions of the section, and it defines, PFAS, but it also means, if you look at B2, any good or product, including containers, materials, parts, or equipment furnished in connection with such goods, products that consist of or contain any chemical in B1. So while I haven't seen it personally, the concern would be that theoretically, if you have a product liability claim that is a product that contains a trace amount of PFAS, which is a lot of products in the marketplace, that the insurers may try to use this exclusion, even if there's no real clear causal connection between the PFAS that's contained in the product and the liability. So that's kind of untested. These are new exclusions. Again, I haven't seen that, but that's one potential risk we want to flag with those exclusions. I think the key takeaway there is just, work with your broker or with counsel if you work with, counsel on these renewals. If your insurance company is trying to add one of these exclusions, There are other forms in the marketplace. A lot of insurance companies have their own proprietary forms, many of which are much better than these two forms. So again, just something to be looking out for when you get into renewal time. So with that, the last part of our presentation here is we wanted to kind of go through a little bit and talk about some best practices for if you are facing a claim related to PFAS. So this is a situation where you don't have the upfront proactive coverage that Matt had suggested, and you're facing a claim, a long tail claim where you've got PFAS alleged exposure over a period of time. What should you do? What are some of the things that you can do to make sure you have the best recovery outcomes? So one thing, one best practice, and we put it number one for a reason, but is if you get a PFAS claim, you really got to locate and try to find all of the old historical policies. So again, most of these claims that we've seen, lawsuits will have an extended long tail period of exposure. And as Michaela went through, those CGL policies potentially are triggered across a number of years and a number of policies dating back decades. So one of the things that you could do to help is to make sure you find all those policies and you can locate those so you know who to notice and who to make a claim against. That can be difficult though, right? If you're looking for policies back from the 60s and 70s that you may not have access to, that could have been purchased and by a predecessor. And so there's a number of things that you can do to try to help find those policies if they're not just readily identifiable in your records. You can ask the insurance company. So if you know who the insurance is, but you don't have the copy of the policy, you can ask the insurance company to provide a copy to you. You can ask your brokers. So maybe you don't even know who the insurer is, or you don't have a copy of the policy, but you know who the broker of record was. You can ask the broker. So you can look at schedules for other transactions. You can hire a professional to go and do these kind of what they call archive work, or archaeology, as they call it sometimes, to go and kind of reconstruct the programs for prior years. So anything else that I might be missing here, Michaela or Matt, in terms of?
I was just going to say, don't be bashful about asking the insurance company for these policies. Oftentimes clients will say, well, I don't know who to ask. I don't know where to go to. I just know this insurance company. Oftentimes I'll just go on LinkedIn and say, who's in charge of their environmental group? I'll send them an email. I'll pick up the phone and give them a call. It's surprising how often insurance companies will look for and find the policies for me. It seems like they'd be like, no, I don't have time for this, but oftentimes they will do it. So don't be bashful about reaching out to them.
Good. Yeah. So,
and then Michaela, really quick.
Go ahead, Matt.
Also, secondary evidence too, like letters that reference policy numbers. We see that too. Sorry.
No. Good.
Yeah, often it's piecing together a lot of secondary evidence, a page of a policy here or there. Oftentimes I'll put a packet together. I have a letter and a piece of a policy, and then I'll send that to the insurance company and say, okay, I have this. Please look for the full policy. Also, I'll just keep going, Joe. You should look for any historic or third parties. Joe touched on this earlier, that could provide coverage. So property owners, contractors, vendors, they may have been required to purchase CGL policies that you might be covered under. This happens a lot in the large construction claims, the large manufacturing claims, where there's several parties and other parties had a duty to provide that CGL coverage. The policyholder should request indemnity directly from that third party, and you can request it from their insured as well. So you can have, tell the third party they have to provide coverage, and also reach out directly to the insured if you know who it is.
Good. Yeah. And another, sort of once you identify those policies or other sources of indemnification, then that next step is to make sure you put all those carriers on notice. And that's just, sometimes, you may just, you have standard practice where you're just going to notice one insurance company, whoever's on the risk, and maybe just the primary insurer, maybe there's excess layers that you're not going to put on notice. But generally, our advice is don't just notice one line of insurance, don't just notice the primary layer, but really give a broad notice across multiple lines. So Michaela covered, D&O could sometimes be implicated. There's other lines of insurance beyond CGL and pollution that could be impacted. And you don't want to limit yourself to a particular year. You might not know where this is going or where the evidence will go in the course of litigation. So it's just better to kind of put everybody on notice, avoid a late notice defense.
Yeah, and often the concern is the clients have is we don't want to notice because it could raise my premiums, on the following year. Should I put this notice in if there's such a small chance? With these legacy policies, chances are you're not using that insurer from 1965 on this policy. So the premium question isn't as much of a concern here. And generally speaking, I don't think it's a smaller concern than most people think in general. But here, the legacy claims, it really shouldn't be part of the calculation because you're not using these claims from these policies from the 1960s. I'll say you should put in the notice if there's any potential of coverage.
So we also touched on this earlier in the presentation too, but so, once you put notice in, you're likely to receive, if the insurance company is doing their job, a letter that sets forth what their coverage position is, at least that is preliminarily what their coverage position is, maybe reserves rights on certain defenses. If it's a CGL policy, we're going to expect that pollution exclusion is going to be raised, issues on trigger and allocation, things like that. Right? And, if it's a first-party policy like pollution, they may ask a bunch of questions, request for information in connection with their investigation. You expect some response for the insurance company. And you may not like the answer, right? So insurance companies don't make money or aren't profitable by paying claims. And so, they will, of course, and they're not your friends, so they're going to look for a way to try to limit or exclude coverage. And so you just need to be careful. Just because the insurance company says this isn't covered, this isn't, we never intended to cover this, or this isn't what the type of risk that this policy covers. Every policy is a little bit different. Every fact is a little bit different, even though some of these policies are written on, relatively formed language. There may be exclusions or limitations or just unique factual issues that could dictate. Also, just where the choice of law that's going to apply, and that may dictate these questions. So, some states, Indiana notably, has a pretty good rule about the pollution exclusion. So you may have a better or different coverage result there than in other jurisdictions. So always just good to kind of take it with a grain of salt.
Yeah, the choice of law is a great point we haven't raised, and it really is key in some of these cases. As I said, the coverage litigation is all over the place and going different ways. So what law applies is really going to have a big impact. And these CGL policies often will not have, these legacy CGL policies will not have a choice of law clause. So there's a lot of up in the air about what law will actually apply. Sorry.
Okay.
That was my fault.
Oh, no, that's okay. Go ahead. You go.
Got ahead of you. I was just going to say, along with not accepting, the reservation of rights, you should understand the role of coverage counsel and when to get them involved and when to engage them is key on these questions. They can, Joe and I start on working with clients when they're just locating their policies. So they think there could be a potential for a PFAS claim down the road. All they're doing is locating their policies, getting them in place. We work with them locating and also with the broker to place the policy. What are my risks here? What kind of coverage do I need? Can you read the policy that's been placed? Tell me if there's any holes or gaps in coverage. And then once a claim comes in, coverage counsel can talk to you, okay, how do I deal with this claim? How do I notice the insurer? How do I work with the broker to do that? How do I, if there's a denial of coverage, how do I push back? What's the best way to push back? Is it litigation off the bat, or is it let's try to have a conversation with the insurance company about where we can go here. An independent review of coverage, I think, is always helpful at the front end or when there's, an actual claim. But if you're a company that thinks you could have exposure, you're collecting your policies now, you should know what's there from the get-go. So when a claim does come in, you're ready to go. Am I missing anything, Joe?
No, I think that's great. I mean, obviously, it doesn't necessarily mean, like I said, that every single, you need to get a coverage counsel involved in every single claim. But, there are, certain issues that, and we'll talk about this too, in certain claims too, where there may just be an advantage in just having a lawyer involved to help protect privilege too, depending on the nature of the claim. So, and that kind of gets into this next topic, right? So is it now after you've made the claim, gotten a response, maybe you've engaged coverage counsel, or you've gotten at least, done an assessment in terms of what your coverage position is, set the strategy, and then you can move forward and kind of work through the claim process. And so we mentioned, there may be requests for information from the insurers. It's very important in some of these matters, especially if it's a complex matter with multiple years, multiple insurers. If it's maybe a big, maybe it's connected to a cat loss claim and there's a potential release of PFAS as a result. It's part of a broader matter. There's a lot of moving pieces. There's a property claim. There's other claims. Just important to be organized. Because again, the insurance company's not your friend, so they're going to want to look for ways to try to build up their own narrative or their own way to deny coverage. And sometimes the way to do that is through a cooperation defense or a late notice defense or some sort of failure to comply with what they call post-loss conditions. So like cooperation notice, getting a proof of loss in on time, things like that. You just got to pay attention and make sure that you're tracking deadlines, tracking how you respond, so that you could be ready to respond to the insurance company if they make a claim. You didn't give me this information, or you haven't cooperated with us in the defense or of the claim. So it's again, just be skeptical. You don't want to be openly antagonistic against, in my view, right, against the adjusters on the other side or the claims handler lawyers on the other side, at least right off the bat. But you need to have a healthy skepticism, in my view. We've seen it where certain clients can get kind of lulled into a sense of security. They'll come in and say, oh, we're here. We want to make it right. We want to help make you whole. We're here to stand behind you. And at the same time, they're working on their coverage denial, and then they blindside people. So just something to keep in mind. Michaela or Matthew, any thoughts on that or just in general kind of ways to manage the claim?
Yeah, be proactive. Don't sit back. Sometimes people say, I haven't heard anything, they're not doing it. Send the insurance company an email. Stay on top of it. You're your best advocate for getting your claim paid.
Yeah, and I would add, whenever there's an environmental matter that comes in, PFAS or whatever, that crosses an insured desk, my mantra is always, when in doubt, report. Even if it comes to nothing, report the claim, because when you go to renewal, it seems somewhat counterintuitive that having a lot of claims reported on a policy could have a good result on an insurance renewal. But pollution claims get expensive when they go unaddressed for a long period of time. So if you demonstrate that you're on top of your environmental risks and you report them once you become aware of them, and 90% of them come to nothing, that actually makes you look like a good risk to the markets.
Good. Well, thank you. That's all we have in our program. We do have a question, and I'll a couple questions, but I think we'll at least have time for one. But there's been a question about just whether or not we'll make this presentation available. I think the answer is yes, but I will defer to Rachel if she's on to confirm that. But I think that we don't have any issue with sharing the deck with the attendees.
That's correct. We will be sending out the presentation via email, and this recording will be available for all attendees.
Good. Okay. So the question that we have is, one of the questions is, can you speak to potential liability of drinking water and wastewater treatment plant owners and operators where PFAS is in the supply or waste sludge? So I've got some preliminary thoughts. I'll kind of get us going, and then I'd like to certainly hear from Matt too and Michaela on kind of their thoughts. But I mean, my thought, just initial thoughts on the wastewater treatment plant exposure would be, I think that there is potential exposure, right? Even if the source of the PFAS is not coming from, in the first instance at least, is coming into the treatment facilities, it's coming from runoff or whatever, just in the wastewater from manufacturing. So, but I could see two ways that could go. Maybe there could be potentially either a regulatory claim or a negligence claim that the wastewater treatment facilities didn't do enough to eliminate that PFAS in the supply. I think that would be my initial reaction is, and I'm not an environmental lawyer, I'm an insurance lawyer, but that would be very difficult to establish because I'm not sure exactly if there is a way to eliminate PFAS through that process. But I think the other way that it could be would just be the fact that maybe the more likely would be depending on what the wastewater treatment facilities uses with the byproduct. So if they're using, which I'm maybe making an assumption about this particular question or the person who answers this question, but they're typically wastewater, they'll use the biosolids and sell it or use it for fertilizer or have other applications. And so the PFAS that may be trace amounts that would be still left in the biosolids, then if that's used in agriculture, and then that becomes, then maybe there's an argument that biosolid then becomes a product and then it's part of the supply chain, and you would have, as an owner, potentially exposure as in the supply chain as providing product liability exposure essentially, or just downstream risk. So from a liability standpoint, I think that's what we'd be looking at. I don't know, and it would be, you'd have to look at it, I think, from the same standpoint of from an insurance coverage the same way you'd be looking at it, depending on kind of the period of time that you're looking at. If you have liability coverage, pollution liability coverage, things like that might be your better source or if you have, certainly your products coverage in your CGL, might still have coverage. You probably don't have a PFAS exclusion, it would be my guess, depending on, in that industry quite yet. But any other thoughts, Michaela or Matt?
I'd say for drinking water supply, third-party bodily injury claims are going to be the biggest source. To a lesser extent, cleanup costs at drinking water treatment facilities where there might be PFAS, in sludge ponds or storage areas. I know that most of the drinking water facilities are required to, or are proactively upgrading their facilities to filter PFAS out to meet the drinking water standards, which creates, more of a construction risk as well as, people upgrade their facilities to meet these requirements. But for drinking water, it's third-party bodily injury claims primarily. For the wastewater sludge that's supplied, yeah, that's primarily cleanup liability from a product standpoint, as well as, to an extent, third-party bodily injury property damage claims as well, because, if PFAS contaminated biosolid sludge impacts farm property, they can't use their farm, therefore they're going to file a loss of use claim. So I think third-party bodily injury for the drinking water and then cleanup toxic tort liability for the sludge that's sold are the two primary liabilities.
Yeah, and just my own part, I know I'm not, as Joe said, I'm a coverage attorney, not an environmental attorney, but my personal opinion, just reading about these things is I think you're going to see more of these third-party claims as the causation is tied closer, when you can tie the actual PFA exposure to the bodily harm. You're seeing more and more articles, scientific articles, tying that causation together. And I think the liability is only going to increase as you see more of that